I came home from a 2-week consulting job in Tucson to find a construction crew working inside my property line. Not near it, not along it, inside it. Concrete mixer still running, footing freshly poured, scaffolding rising toward what would become a 12-foot covered balcony extending 4 feet over my backyard, built by a company called Tate Construction, under a contract awarded by an HOA board president whose husband happened to be a registered member of that same LLC. Nobody had called me. Nobody had written to me. Nobody had arranged for a survey or a homeowner notice or any of the things Arizona law requires before you build something that shadows someone's property. Diane Halverson had simply decided my backyard was close enough to the clubhouse that the property line didn't really need to be respected. I pulled out my survey. I got out my tape measure. I started photographing. Then I hired an attorney. What happened next took 11 months. It involved a building department investigation, a state contractor license suspension, a TRO in County Superior Court, and a packed annual meeting where a city inspector stood up from the 4th row and confirmed, on the record, that a formal non-compliance notice was already in effect. You're going to want to stay for this. Where are you watching from tonight? Let me tell you about Mesquite Ridge Estates. It's a planned community in Scottsdale, Arizona, the kind of place where the HOA sends you a written violation notice if your mailbox flag is the wrong shade of beige. 340 homes, all in shades of tan, sand, and desert clay, arranged around a central clubhouse and pool. The lawns are irrigated on a schedule published in the monthly newsletter. The shrubs are trimmed to a regulation height. Even the holiday lights have rules. White only, no more than 1 roofline string per house, down by January 15th, and the HOA is not joking about that deadline. People have received letters about it. I moved to Mesquite Ridge 6 years ago, after my divorce. My ex got the beach house vacations and the social circle. I got the house, our house, the one we'd bought together back in 2011, which, depending on how you look at it, was either a consolation prize or a head start. I chose to see it as a head start. The house sat on a corner lot, a little more space than the neighbors had, with a backyard that caught good afternoon sun from about 2 o'clock until dusk. I'd built a workshop out there over the first 2 summers, set up a pergola with a ceiling fan and a couple of hanging lights, planted a lemon tree that had no business being as productive as it was, but I wasn't complaining. That backyard was my quiet place, my reset button after a long day of reviewing load calculations in someone's conference room. I'm a structural engineer by training, semi-retired now, picking up occasional consulting work, reviewing commercial plans, inspecting existing structures, signing off on load calculations when a smaller firm needs a licensed second opinion. I've spent 30 years reading blueprints and understanding exactly what happens when structures fail. I understand load paths. I understand footings. I understand property lines, which made it especially strange when a construction crew decided to pour a concrete footing inside mine. The trouble started in March. I was away for 2 weeks on a consulting engagement in Tucson. A commercial renovation review, nothing exciting. Mostly existing structure inspections in a building where someone had removed a load-bearing wall in the 1990s and hoped for the best. When I came back to Scottsdale, I noticed construction equipment staged along the east side of the HOA clubhouse, which sits adjacent to my backyard fence. Big stuff. A concrete pump truck parked on the access drive, scaffolding going up along the east wall, bags of Quikrete stacked on a wooden pallet. I assumed the HOA was finally addressing the roof section that had been sagging at one corner for 2 years. Complaints had gone out. I figured they'd finally gotten around to it. I didn't think much of it. 3 days later, I walked out my back door and stopped cold. A concrete footing, freshly poured and curing, sat approximately 1.5 feet inside my property line. I stood there for a solid minute, just stared at it. The smell of curing concrete hit me before I'd even registered what I was looking at. That alkaline, dusty smell, slightly sweet, the way every construction site smells in those first few days. A construction worker in an orange Tate construction vest noticed me from across the fence line and gave me a casual little wave. The kind of wave that says, "Yeah, I see you," and "No, I don't think this is a problem." It was a very large problem. I walked back inside, went straight to the filing cabinet, and pulled my original property survey, the full certified boundary survey from when I closed on the house, with the meets and bounds description, the lot corners plotted, the dimensions certified by a licensed Arizona land surveyor. I spread it on the kitchen table. I got out my engineer's measuring tape, the good one, steel, graduated in tenths of feet, with a locking mechanism that doesn't slip. I walked back outside, found my corner markers, and ran the tape. The footing was 1.4 feet inside my property line. Based on the framing already rising above it, the covered balcony Tate Construction was building would extend approximately 4 feet over my backyard. 4 feet of someone else's balcony hanging over my pergola, my workshop, my lemon tree, built while I was out of town, without my knowledge, without my consent, without so much as a courtesy letter. I called the HOA management company that afternoon, left a message. Nobody called back. I drove to the management office the next morning, where a property manager named Ron, who had the energy of someone who had permanently set his ambitions at get through the day, handed me Diane Halverson's contact card without making eye contact. I called Diane that evening. The call lasted 4 minutes. She told me the board had approved the project. She told me the community had been informed. She told me the structure was entirely within HOA common area. I told her I had a certified survey that disagreed. She said, "It's just a few feet, Garrett. You're being petty. The community voted." That was the moment I understood that patience, for someone like Diane, looked exactly like surrender. So I decided to stop being patient. Let me tell you who Diane Halverson was in this community. 9 years as board president is a long time. Long enough to learn every bylaw by heart, to know every committee chair by name, to identify which homeowners push back and which ones fold after a single fine notice. She knew which city inspector liked to be met at the gate with a friendly explanation and a water bottle. She knew the property management company answered to the board, not to individual homeowners. She'd built a comfortable little power structure inside Mesquite Ridge, and she had learned, correctly, for 9 consecutive years, that most people in this community would rather absorb a fine and go back inside than spend their evenings fighting a bureaucratic structure designed to exhaust them. Diane wore the HOA logo on every polo shirt she owned. She drove a white Lexus SUV with a proud HOA board member bumper sticker, which tells you something specific about a person. Not that she was proud of service, but that she wanted everyone to know she was. She carried herself with the confident authority of someone who had never been seriously challenged, which in HOA terms is the most dangerous kind of person you can be dealing with. I am, by nature, methodical rather than confrontational. Engineers don't argue. We document. We measure. We build cases out of evidence rather than volume, because in the long run, a stamped drawing beats a loud opinion every single time. So I started building my case. I wrote a formal written complaint, not an email, an actual letter, sent certified mail with return receipt requested. I addressed it to the board president, the full board, and the property management company. I attached photographs, the freshly poured footing, the tape measure laid from my corner marker to the concrete, the Tate Construction scaffolding rising in the background. I attached a copy of my certified property survey. I cited by section number the clause in the HOA's own CC&Rs, the covenants, conditions, and restrictions that specifically addressed construction adjacent to individual lot lines. My language was measured and factual. I asked for an immediate halt to all construction pending a boundary survey by a neutral licensed third party. I mailed it certified with return receipt. I kept a copy. I logged the tracking number in a notebook I'd started keeping. The board's next meeting was 11 days away. I went. The meeting room smelled like burnt coffee and someone's floral perfume, heavy, the kind that lingers. I sat in the back and waded through 45 minutes of agenda items about pool hours, a vendor contract for the landscaping service, and a lengthy discussion about whether the community newsletter should go to full-color printing. Then Diane acknowledged my letter. She held it up briefly. "We've received a written concern from homeowner Garrett Wills regarding the East Balcony project." She set it down. "The board has reviewed the concern, and we are confident the construction is within HOA common area. We will respond in writing." A man in the third row raised his hand and asked whether a licensed surveyor would be brought in to verify. Diane said the plot plan on file was sufficient. A board member in the far corner nodded, with the enthusiastic agreement of someone who had long ago decided that agreeing was easier than thinking. 2 days later, Diane's written response arrived, via regular mail, no return receipt. She stated that I had misread the survey, that construction was proceeding within approved parameters, and that the HOA reserved the right to take enforcement action against homeowners who made false or misleading claims against the association. And then, at the bottom, a $250 fine for creating community discord. I read that 3 times. Then, I put the letter in a folder. I labeled the folder Mesquite Ridge File and put it on the corner of my desk. The folder was already starting to get thick. The thing about petty authority is that it treats your calm, documented response as proof you don't have a real case. Diane saw my certified letter, my photographs, my survey, my attendance at the board meeting, and apparently concluded I was the type of person who could be fined into silence. She had not yet considered the possibility that she was dealing with a retired structural engineer with an extremely organized filing system and a fundamental professional problem with structures built in the wrong location. Construction continued. The balcony went up. With framing going up fast on the east wall, I made my next move. I called the City of Scottsdale Building Services Department and filed a formal complaint. This is something most homeowners don't think to do, so it's worth pausing on why it matters. When a contractor builds a structure, they pull a permit. That permit is issued based on a plot plan, a drawing showing exactly where the structure will sit relative to property lines, setback requirements, and easements. If the finished structure doesn't match the permitted plot plan, the city can issue a stop work order and require corrective action. The city doesn't care who's popular in the HOA, it cares about the drawings. I called, explained the situation without editorializing, and a building inspector was assigned to come out within the week. In the meantime, I went to Scottsdale's online permit portal, public record, accessible to anyone, and looked up the permit Tate Construction had pulled for the balcony project. The permit was there, the plot plan attached to it was there, and what I saw on that plot plan was instructive. The structure was shown terminating precisely at the HOA's common area boundary. Clean line, no encroachment. Whoever had drawn that plan had been careful, or, more accurately, strategic, because the structure being built in reality, 4 feet past that line, into my yard. The inspector came out on a Wednesday morning. His name was on the work order, a man assigned to the Scottsdale Northeast District. I watched from my backyard gate as he arrived on site, and, simultaneously, Diane Halverson's white Lexus pulled up on the access drive, which I do not believe was a coincidence. She met him at the clubhouse entrance before he'd taken 3 steps, water bottle in hand, smile ready, the full hospitality treatment, and walked him through the exterior with the practiced ease of someone who had handled inspectors before. She pointed at the structure. She spoke. She gestured broadly at the framing in a way that suggested everything was obviously fine. Just a routine community improvement, nothing to look twice at. He looked. He nodded. He left without issuing a stop work order or making a single measurement. I stood in my yard watching that white Lexus pull away, and felt something I hadn't felt in a while. Not rage, something quieter than rage. The particular frustration of watching a system bend towards someone because she knew exactly which levers to touch. She had probably done this precise thing before, with this inspector or ones like him. She'd had 9 years of practice. I stayed methodical. 2 days after the inspector's visit, a certified letter arrived. Diane had learned from me that certified delivery carries a weight that regular mail doesn't. The letter informed me I was being fined an additional $500 for interfering with HOA operations and filing a bad faith complaint with a municipal authority. $500. For asking a city official to perform a city function. I put the letter in the folder. The balcony was essentially complete by this point. It rose 12 feet above my backyard, a covered deck with new lumber still smelling of the sawmill, board rails freshly painted in the HOA's regulation sand color. Every weekend when the clubhouse hosted an event, I could hear voices directly above my pergola, conversations, chair legs scraping on deck boards, occasional laughter from people who had no idea they were standing 4 feet over my property line. On Saturday afternoons, the shadow it cast covered the section of my yard that had gotten the best afternoon sun. My lemon tree, which had always leaned slightly east toward that light, was starting to look confused about the change. The smell of new pressure-treated lumber was still sharp in the afternoon heat when I made my next discovery. And that discovery was the one that changed everything. Engineers are professionally curious. It's how the job works. You don't take a structure at face value. You ask how it was built, who approved it, what's holding it up, and whether anyone checked the math. That same instinct, applied to a HOA, turns out to be very useful. I knew Tate Construction had the balcony contract. What I started wondering was how they'd gotten it. The HOA had used Tate for 5 years' worth of major projects: pool resurfacing, roof replacement, parking lot repaving, and now this. That's a lot of repeat business. In the private sector, repeat business usually means either exceptional service or an exceptionally comfortable relationship with the decision maker. I wanted to know which one this was. I filed a homeowner records request with the HOA management company. This is a tool that most HOA members don't know they have, but Arizona revised statutes are actually reasonably strong on this point. Any homeowner in good standing may request access to HOA financial records, meeting minutes, and contracts, and the association must produce them within 10 business days. The statute is clear. The request is simple. You write a letter, you cite the statute, you ask for what you want. I asked for all financial records for the past 3 fiscal years, all board meeting minutes for the same period, and the complete construction contract with Tate Construction, including any addenda or change orders. Diane responded 13 days later, already past the statutory deadline, which I noted, with a packet of documents so heavily redacted it looked like declassified intelligence material. Contract values were blacked out. Vendor payment totals were redacted. The meeting minutes from the session where the balcony contract was approved read in their entirety. Board approved East Balcony renovation project. That was the complete entry. No discussion summarized, no vote recorded, no dissent noted. I filed a second request, citing by section number the statutory provisions she'd violated by redacting without stated legal justification. In the meantime, I did some public record searching of my own. Arizona Secretary of State business filings are searchable online. I looked up Tate Construction LLC. I examined the registered agent. I looked at the listed members of the LLC. One of the registered LLC members was a man named Philip Halverson. I sat with that for a moment. Then I looked up the HOA's own bylaws. Article 7, Board Member Conduct, stated in plain English that board members were prohibited from voting on or approving contracts with any company in which they or their immediate family members had a financial interest, without full written disclosure to all homeowners and a subsequent separate homeowner vote. There had been no disclosure. There had been no homeowner vote. Diane had voted to award Tate Construction, a company of which her husband was a registered member, contracts worth tens of thousands of dollars over 5 consecutive years, and had apparently never told a single resident of Mesquite Ridge. That is not a misunderstanding of the rules. That is a textbook violation of fiduciary duty. Under Arizona law, board members who breach their fiduciary duty to the association can face personal liability, meaning Diane wasn't just the HOA's problem. She was potentially her own problem. The fine she hit me with that same week, $750 for continued harassment of board members, barely registered at this point. I wrote the amount in my notebook and moved on. The Mesquite Ridge file binder was genuinely heavy now. I had to move it from the desk to the shelf. Sometimes you think you're building a complaint. Then you step back and look at what you've actually built, and you realize it's something else entirely. I spent a Saturday morning laying everything out on my kitchen table in chronological order. Survey, photographs, permit, plot plan printout, HOACC and Rs, flagged at relevant sections, Arizona statutes, printed and tabbed, LLC filing for Tate Construction, the redacted records request response, my fine notices, the city's original non-action report, every certified mail receipt. The contents of what had started as one folder now occupied most of a tabletop. I looked at it the way I'd look at a structural analysis. Identify the elements, map the connections, find where the load paths go. What I had was not a complaint. What I had was a case. Here's what it showed, layer by layer. The HOAs, CC and Rs, Mesquite Ridge Estates, Article 8, Section 8.4, were explicit and without exception. No structure may be erected, placed, or extended so as to encroach upon an individual homeowner's lot without that homeowner's prior written consent. Not minimal encroachment. Not incidental overlap. Any encroachment required written consent. I had never given consent. I had never been asked. I had never received so much as a preliminary inquiry. Arizona Revised Statutes, Section 33-1803, requires planned community associations to provide written notice to any homeowner whose property will be directly impacted by a construction project before work begins. The notice must describe the project and its potential impact. I had received nothing. The building permit Tate Construction pulled showed the structure ending cleanly at the HOA property boundary on the plot plan. The actual structure extended 3.9 feet past that boundary. That means either the plot plan submitted for the permit was inaccurate, a permit violation, or the structure was constructed in a location different from what the permit authorized, also a permit violation. Neither option was comfortable for the contractor or for whoever approved the drawings. Submitting inaccurate drawings to obtain a building permit is not a paperwork error. It is the kind of thing building departments take seriously. And then there was Philip Halverson's name on the Tate Construction LLC filing. His wife had been the sole decision-making authority, awarding Tate contracts for 5 years without disclosure. That is a breach of fiduciary duty, a real legal term with real legal consequences, not a complaint category that gets you a fine notice. Every piece of what Diane had done, the construction without notice, the encroachment without consent, the inspector management, the fraudulent plot plan, the undisclosed conflict of interest, was a separate, documented, addressable legal problem, not one big, vague grievance, distinct, specific, provable violations. I called Patricia Engel on a Monday morning. She was a real estate attorney in Scottsdale who had built her practice almost entirely around HOA disputes, which tells you something about the market demand for that specialty. I walked her through what I had in about 20 minutes. There was a pause when I finished. "You documented all of this as it happened?" she asked. I told her yes. Certified mail, photographs, timestamps, tracking numbers, the works. Another pause. "Okay, let's talk about how we proceed." That conversation was the moment the dynamic shifted. Up until then, Diane held all the institutional power. She had the board, the management company, the HOA attorney, the community's social inertia, and 9 years of unchallenged authority. What she had failed to account for was an opponent who had spent 3 decades solving problems by building an airtight case first and then acting. From this point forward, we weren't responding to Diane. Diane would be responding to us. If Diane Halverson thought she was dealing with a frustrated homeowner who'd eventually get tired and go away, what she was actually dealing with was a semi-retired structural engineer with methodical habits, 2 binders of organized evidence, and absolutely nothing better to do on a Saturday afternoon than build a legal strategy. The first thing Patricia recommended: commission a new certified boundary survey. Not my original survey from closing, a fresh one, conducted specifically to document the encroachment, performed by a current licensed Arizona surveyor, signed, sealed, and legally defensible as a court exhibit. I hired Clearwater Land Services, which I found through the Arizona State Board of Technical Registration's public licensed firm database. A surveyor named Jeff came out on a Thursday, spent 4 hours on site, set new brass corner markers, and produced a stamped boundary survey showing the balcony structure extending 3.9 feet over my property line at its maximum point. Stamped, certified, legally binding. Something that couldn't be explained away with a wave of the hand and a smile for the inspector. The second move: Patricia filed an amended complaint with City of Scottsdale Building Services. Not a phone call this time. A formal written submission with numbered exhibits. The new certified survey, a copy of the permit's plot plan, and a side-by-side comparison visually demonstrating the discrepancy between where the structure was permitted and where it was actually built. She used the phrase "fraudulently obtained permit" in the cover letter, deliberately, because that specific language triggers a different level of review than possible error. Building departments have processes for permit errors. They have different, more serious processes for permit fraud. Third, Patricia filed a complaint with the Arizona Registrar of Contractors against Tate Construction, charging them with constructing a permanent structure over a private property boundary without the affected homeowner's consent or a recorded easement, in a location inconsistent with the approved permit. The registrar is the state agency that licenses contractors in Arizona. Contractors can lose their license over complaints like this, and they know it. An open investigation affects bonding, affects permitting, affects the ability to bid on future work. I was not the first homeowner to be harmed by a contractor willing to cut corners at someone else's expense, and the registrar keeps records. Fourth, and this was the part that surprised me most, I started talking to my neighbors. I'd been in Mesquite Ridge for 6 years. I knew the people on my immediate block the way suburban neighbors know each other. Well enough to wave, well enough to exchange pleasantries at the mailbox, well enough to know who had a dog and who put their bins out early. What I didn't know was how many of them had stories of their own. I started quietly. A conversation over the back fence here, a timed mailbox walk there. Over 3 weeks, I found 6 homeowners with substantive grievances. Fines issued without proper notice, complaints dismissed without response, records requests denied or significantly delayed. One family had been threatened with lien action over a dispute about the color of their patio tiles, a color the CC and Rs didn't actually prohibit if you read them carefully. An older man named Dale, who'd lived in Mesquite Ridge since the community was built, had received 8 separate fines in a single calendar year, and had never received a coherent explanation for any of them. We started meeting on Sunday evenings at Dale's place. 7 homeowners, coffee, a dining table covered in documents. I walked everyone through what I had found, and what their rights were under Arizona HOA law. People wrote things down. A woman named Irene, who had brought a legal pad, filled 6 pages. Patricia also explained that the HOA's own CC&Rs, along with Arizona statute, required an annual homeowner meeting at which board officers could be removed by a majority vote of the members present and voting. The annual meeting was 6 weeks away. We had a concrete deadline and a clear objective. Patricia filed in Maricopa County Superior Court for a temporary restraining order, asking the court to prohibit the HOA from allowing any use of the encroaching portion of the balcony, pending resolution of the encroachment dispute. The TRO hearing was set for 3 weeks out. Under the TRO, the structure wouldn't come down immediately, but it also couldn't be used. Diane would not be hosting rooftop events over my backyard while a court case was pending against her. Arizona is a one-party consent state for audio recording, which means any party to a conversation can legally record it without notifying the other party. Every interaction I had with Diane, the management company, or HOA representatives going forward was recorded. I kept a time-stamped log of every call, every letter, every certified mail tracking number, and every document I received, in the order I received it. The binders on my shelf were 2 now, and growing. The balcony still hung over my yard, casting its shadow across my pergola every afternoon. But I knew something Diane didn't. The shadow had a timer on it. When a person like Diane Halverson realizes she's losing control of a situation, she doesn't quietly reassess. She doubles down, loudly, in multiple directions at once. I've seen this pattern in bad project managers. Same psychology. When the facts turn against you, flood the zone with noise and hope the other side gets tired. The noise campaign started about 2 weeks after we served the HOA with notice of the TRO filing. First, Diane called an emergency board meeting and pushed a motion to retroactively amend the CC&Rs to allow for the balcony's existing footprint. The problem with this was fundamental. Arizona HOA law requires a 2/3 vote of all homeowners, not a board vote, to amend CC&Rs. Diane tried to characterize the motion as an administrative clarification rather than a true amendment, which would allow the board to pass it alone. Patricia sent the board a 1-page letter explaining, with statutory citations, that the characterization was incorrect and that any unilateral CC&R modification without a homeowner vote would constitute an independent statutory violation, adding to, not resolving, the HOA's legal exposure. The motion was tabled. 2 board members voted against even putting it to a vote, which I found interesting. Second, Diane sent a letter to all 340 homeowners in the community. She described my TRO filing as a lawsuit against our clubhouse, and suggested I was attempting to tear down the property values of Mesquite Ridge Estates. She did not mention the property line encroachment. She did not mention the building permit discrepancy. She did not mention her husband's registered membership in Tate Construction. She presented the entire situation as one disgruntled neighbor, creating conflict over a community improvement project. Some homeowners I didn't know sent me emails. A few were hostile. Several were curious. One couple 3 streets over reached out to say they'd had issues with the HOA they'd never known how to address. I passed their contact to Dale, who added them to the Sunday evening group. Third, the HOA's attorney, a man named Blaine, who communicated exclusively on very heavy cream stationery, as though weight could substitute for substance, sent Patricia a cease and desist letter, alleging that my certified survey, my records requests, and my communications with neighboring homeowners constituted tortious interference with the HOA's operations, and demanded I withdraw the TRO filing. Patricia replied in 4 paragraphs. The reply was professionally crushing in the way that only a very good attorney who knows exactly what she's looking at can be professionally crushing. The final paragraph noted that she would be happy to discuss settlement terms if the HOA wished to avoid the cost of prolonged litigation. They did not respond. Fourth, Diane attempted to refer my outstanding fine balance, $1,500 across the 3 notices, to a collections agency. This is a real HOA tactic, and it can affect credit. Patricia filed an emergency motion requesting the court hold collections action in abeyance, pending resolution of the larger dispute, on the grounds that all 3 fines were retaliatory in nature and issued outside the HOA's proper enforcement procedures. The judge granted a temporary hold. Diane was throwing everything she had at the wall. She'd spent 9 years learning which things stick against ordinary homeowners in ordinary disputes. She had not yet accepted that this was not an ordinary dispute, and I was not an ordinary homeowner. What Diane didn't fully understand, because she was managing optics rather than watching the machinery, was that while she was running her PR campaign, 3 separate institutional processes were grinding forward in the background, entirely outside her reach. The Arizona Registrar of Contractors sent me an acknowledgement letter confirming that the complaint against Tate Construction had been assigned for formal investigation. A formal investigation is not a form letter. Contractors under active investigation face restrictions on bonding capacity. They face heightened scrutiny when pulling new permits. Other associations conducting due diligence before awarding contracts, and responsible boards do conduct due diligence, would find an open investigation and would ask questions before signing anything. Tate had built its business on a steady stream of HOA contracts in the Scottsdale area. An open registrar investigation was the kind of thing that made that stream run slower. Scottsdale Building Services, meanwhile, assigned a senior inspector and a supervisor to conduct a formal site review of the balcony structure. This visit was not announced to the HOA in advance, which Patricia had specifically requested in her amended complaint, noting that a prior inspection had been managed in a way that prevented accurate assessment. The 2 inspectors arrived on a Tuesday morning with the original permit file, a digital measuring device, and no prior briefing from anyone with a white Lexus. They measured. They compared the as-built location to the permitted plot plan. They documented the discrepancy in writing. Then, they issued a formal notice of non-compliance. The notice stated that the balcony structure had been constructed in a location that did not conform to the approved permit drawings, and required the HOA to either demonstrate the structure was within permitted bounds, which it could not do because it wasn't, or obtain a corrective permit reflecting the actual footprint. A corrective permit for a structure encroaching over a private property line would require a recorded easement from the affected property owner. That was me, and I had no intention of granting one. The building department simultaneously flagged the file for potential permit fraud review. Someone had submitted drawings showing the structure ending at the property line. The structure had been built 4 feet past it. Either the drawings were wrong or the construction was wrong. Neither option was a paperwork mistake. Both required explanation. In the middle of all this, I had 2 separate conversations with HOA board members who had grown quiet and worried. They came to talk to me through Dale, separately, without Diane knowing. One told me she had felt pressured to vote in favor of the balcony project, and had not been informed that there was a property line question. She had assumed, because Diane said so, that the project had been properly reviewed. The other, a soft-spoken man named Everett who had been on the board for 3 years, said that Diane had personally approached him and asked him to sign a document that, as he described it, would have granted the HOA a retroactive easement over my property. He had refused, and he had kept a copy of the document she'd asked him to sign. He gave it to me. A local real estate journalist named Amanda, who covered HOA disputes for the Scottsdale Independent, called me that week. She'd heard from someone in our coalition that there was a story developing. I spoke with her for 30 minutes, entirely on background. I confirmed that there were active court proceedings, an active building department investigation, and an active registrar of contractors investigation, all public record. I did not provide documents. She was capable of finding the rest herself. She did. Her piece ran the following Thursday, 4 days before the annual meeting. The annual meeting for Mesquite Ridge Estates was held on the 3rd Thursday of April, in the clubhouse meeting room, the same room where, 10 months earlier, I'd sat in the back and watched Diane wave my certified letter at the room and set it face down without discussion. This time, the room looked different. 112 homeowners, folding chairs crammed into every available space, people standing along the back wall and both side walls. A few residents had brought their own chairs from home, rather than wait for the HOA to produce more. The air smelled like warm coffee from the urn in the corner, and the particular energy of a room full of people who have decided to pay attention. Diane sat at the board table at the front, in her blue HOA polo, her visor resting on the table beside her. Her expression when she walked in and registered the size of the crowd was something I'll remember. Not panic. She was too experienced for visible panic. Something more controlled than that. A recalibration happening behind the eyes. Patricia sat beside me near the front. Dale was on my other side. Several coalition members were distributed through the room. Amanda from the Scottsdale Independent sat in the far back with a notepad and a small recorder. And, in the 4th row, sat Frank Rios, a homeowner I'd exchanged maybe 3 conversations with at the mailbox over the years. I hadn't known until that week that Frank worked for Scottsdale Building Services. The meeting opened with the standard agenda: pool hours for summer, landscaping contract renewal, then board elections, the item that had brought most of the room there. Diane moved to open a floor comment period before the vote, which I believe she intended as a chance to shape the narrative one final time. She made a brief prepared statement describing the ongoing legal matter as the product of a single homeowner's misunderstanding of the survey process, and assured residents that the board had acted in the community's best interests throughout. When the floor opened for homeowner comments, I walked to the podium. I had one document, a single printed page, double-sided. Coalition members distributed it as I approached, 1 copy per household represented in the room. Front side, a side-by-side image of the Tate construction permit plot plan versus a photograph of Jeff's certified survey, with the 3.9-foot encroachment marked clearly in red. Backside, a numbered timeline of events, the relevant CC and R section quoted verbatim, the relevant Arizona statute, and the key operative language from the building department's notice of non-compliance. I did not raise my voice. I spoke the way I speak to clients reviewing structural findings, clearly, with dates, in order. I described the footing I found inside my property line when I came home from Tucson. I showed the permit drawing versus the certified survey. I explained what Section 33-1803 required and confirmed what had not been done. I explained the CC and R language about property line encroachments and written consent. I described what a notice of non-compliance meant and what the building department had now formally required. Then I mentioned that a current board member had been asked by Diane to sign a document granting a retroactive easement over my property, without my knowledge or consent, and had refused and preserved evidence of that request. The room went very quiet. Diane stood. That is a complete mischaracterization of... Frank Rios stood up from the 4th row. He identified himself by name and by employer. Then he said, in a straightforward and unhurried voice, that the City of Scottsdale Building Services had issued a formal notice of non-compliance on the balcony structure, that the permit file had been referred for fraud review, and that a corrective action timeline was now formally in effect. He sat back down. The room stayed quiet. Diane said, "Garrett Wills is doing this because he wants to tear down what this community has built." Patricia stood. She read aloud the CC&R section, prohibiting encroachment without homeowner consent. Then the Arizona statute. Then the operative paragraph of the Maricopa County Superior Court temporary restraining order, issued 4 days prior, which prohibited the HOA from allowing any use of the encroaching structure, pending resolution of the underlying dispute. She held the signed court order up so the room could see it. A woman near the back wall said, in a clear and genuinely curious voice, "Why didn't any of us know about any of this?" Nobody at the board table answered that. The vote came about 20 minutes later, after 3 more homeowners spoke, including Irene with her legal pad, who cited the statutory deadline violations on the record's requests by section number. Diane Halverson was removed from the position of board president by a vote of 91 to 21. 2 other board members resigned before the tally was finished. An interim board of 5 homeowners was elected by acclamation. Dale, Irene, Everett, a recently retired civil engineer named Marcus, and Claudette, a former middle school principal who had asked 4 precise and excellent questions from the audience and, based on how quickly the room responded to her, was clearly the right person to run things going forward. When Diane gathered her things and walked out of the meeting room, she did not look back. I stayed and helped stack the folding chairs. It seemed like the right thing to do. The resolution, when it came, was not dramatic. It came the way most things do in engineering and in law, through an ordered sequence of steps, each one following logically from the last, until the work was simply done. 3 months after the annual meeting, Maricopa County Superior Court ruled in my favor on the encroachment claim. The HOA was ordered to remove the portion of the balcony extending beyond my property line at the association's expense. The contractor selected for the removal was not Tate Construction. By that point, Tate was operating under a suspended license, while the Arizona Registrar of Contractors completed its investigation. The registrar ultimately issued a formal reprimand and a 6-month license suspension, a serious consequence in a state where the construction market moves as fast as Arizona's. All 3 of my fine notices, the $250 for community discord, the $500 for interfering with HOA operations, and the $750 for harassment of board members, were rescinded by the new board in their first official meeting, on a unanimous vote. The HOA's insurance carrier, notified of the litigation through the court proceedings, settled my attorney's fees as part of a broader claims resolution. Patricia's invoice did not come out of my pocket. Diane and Philip Halverson put their house on the market in May. It sold in August. I saw the moving truck from my backyard. The new interim board, Claudette presiding, with the efficient warmth of someone who had successfully managed a building full of 12-year-olds for 2 decades, moved quickly once they had authority. They commissioned an independent financial audit of HOA records for the prior 5 years. They adopted a new contractor procurement policy, 3 competitive bids required for any project over $10,000, mandatory conflict of interest disclosure forms for all board members, and a prohibition on awarding contracts to any company with financial ties to a board member or their immediate family. All board meeting minutes would be posted publicly on the HOA website, which had previously existed solely to display pool hours and the holiday light rules, within 5 business days of each meeting. And with the reserve funds that had been informally earmarked for future Tate construction work, money that was now redirected, the new board surveyed all 340 homeowners and asked what they actually wanted for the community's common spaces. The answer was clear: proper shade structures for the outdoor seating areas, installed by a licensed and vetted contractor through a fully transparent bid process. They also asked for something that had been missing for 9 years: a homeowner rights information packet, a plain language document explaining what HOA members could formally request, what fines could and couldn't be issued for, how to file a complaint, and what the statutory deadlines were for HOA responses. Something that translated the legalese of the CC and Rs into sentences any resident could read on a Wednesday evening and understand. Claudette asked if I'd be willing to help draft it. I said yes. I also agreed to serve on the Construction Oversight Committee for the Shade Structure project, reviewing the bid drawings and the permit applications before anything was approved or submitted. Old habits. The lemon tree is doing well, by the way. The afternoon light came back to that corner of the yard as soon as the encroaching section of the balcony came down. Last fall, I harvested about 40 lemons, which is, honestly, more than any single person should have to deal with. I left bags of them on 6 neighbors' doorsteps with no note attached. I think they knew where they came from. If you've ever dealt with a HOA that invented its own rules, dismissed yours, and thought it could fine you into silence, leave your story in the comments. You are not alone, and you have more rights than they want you to believe you do. Share this video with someone who needs to hear that. And if you want to see what happens when a homeowners association learns the hard way that nobody is above a stamped survey and a county court order, hit that subscribe button, because we have more stories exactly like this one. Next time, a homeowner in rural Tennessee spent 11 years in a property line dispute with a logging company and won. Using a hand-drawn map from 1887 and a local historian who'd been waiting his whole career for someone to ask the right question. You're going to want to stay for that one.